Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. The Idaho versus Kohberger case was unprecedented in many ways, one of which was the apparent secrecy of this case. While it was prosecuted actively from December 29th, 2022 until July 23rd, 2025. At that point, at the time of Mr. Kohberger's sentencing, the criminal case, for all intents and purposes, ceased. However, the case is still active because of the many documents that were filed under seal, meaning out of the public domain. And it is until one looks at the case from the very beginning through its closure, you will note then and appreciate then just how many items were sealed from the public. Sometimes based on court orders granting motions to seal that the state filed or the defendant filed, or in some instances, both of them filed together. You will not find one court order denying anything to seal. Number two, adding to the secrecy, was the gag order, the non-dissemination order that Judge Marshall, the first jurist of the case, entered on a stipulation by both sides. A stipulation signed by Ann C. Taylor, who drafted that first non-dissemination proposed order, and asked Mr. Thompson if he would join in a stipulation, an agreement, rather than just the defense going to the court, which he did. There were efforts to try to get it set aside. All of them failed until the media got involved in July of 2025 and finally persuaded Judge Hippler to set aside that gag order after Mr. Kohberger pled guilty. Oh, and by the way, the defense, Ms. Taylor, opposed that gag order being set aside at that time. The third item that added to the secrecy of the case are all of the hearings upon hearings upon hearings that were held behind closed doors. Today, as we approach the beginning of May, it is Saturday, April 25th, as I am recording this. It is going on 1 year since Mr. Kohberger changed his plea from not guilty to guilty, which canceled the trial when the public anticipated that the state would be going into Judge Hippler's courtroom in front of a jury and presenting its evidence to prove in this capital case that Mr. Kohberger and Mr. Kohberger alone was guilty beyond a reasonable doubt evidentiary standard. That never happened because of change of plea. The media filed a motion to open up the case, to unseal the case. In July of 2025, Judge Hippler said no. He denied that motion. He announced that there would be a process whereby he would be going through a few months at a time, starting from the end of the case and working backwards to determine which of the records under seal should be unsealed to the public. And that process worked for a few months. Judge Hippler would go to the parties. He would ask them, of these documents from this time period, give me your objections or non-objections to unsealing them. And the parties did until the third order seeking the parties' position regarding sealed documents. It is dated October 16th, 2025. What it did, like the first one, which asked for the parties' input as to documents from June and July of 2025, and the second order dealing with documents from April and May of 2025. This one was different in two ways. First, it asked for the parties' input for 3 months of documents, January, February, March of 2025. The second reason why it was a little different is because now they were getting into documents under seal, the motions in limine briefings. Motion, what is a motion? An application for a court order. In limine, that means before trial. And if you look at the motions, responses, and replies, and you can find them on the docket. They were filed in February and March of 2025. They asked in many instances, the state, the defense, and on other occasions, Judge Hippler were asking you in limine for a ruling to either keep this evidence in the jury trial or keep it out in the jury trial. Remember, in February and March of 2025, there still was that trial that was supposed to happen in August of last year. And if you look at some of those motions in limine, you will see requests for rulings on evidence dealing with such crucial matters as AT&T timing advance records, motions in limine dealing with IgG DNA evidence, which goes to that sheath, that none of the first responders who went into that house from the Moscow Police Department in their reports wrote that they noticed a sheath. And I'm referring to the reports of Officer Nunez, Officer Warner, Sergeant Gunderson, Officer Snyder, and also Officer Smith. Those were the 5 that entered 1122 King Road at noon or shortly thereafter. And all 5 of them went up to the 3rd floor. And not one in their reports mentioned a sheath. And you can hear none of them on body cam as they're talking to each other on November 13th, speaking of a sheath. The other in limine filings dealt with suspect vehicle 1, witness identification by bushy eyebrows, Amazon click history, and Amazon is where the state alleges that Mr. Kohberger purchased the sheath that was allegedly found on the bed next to 2 of the victims, Kaylee and Madison. It took a little bit more time for the court to enter his order on this 3rd order seeking parties' position regarding sealed documents, but he finally did on December 18th, 2025. What he said, first part of that court order listed dozens of documents that Judge Hippler ruled would be released to the public without redactions. The second part addressed those that would not be released, that would remain under seal. And then the 3rd section discussed the documents that the court ordered December 18th, 2025 would be released without redactions. In total, there were 90 documents from January, February, and March of 2025 were to be released to the public. As of today, one of those documents were released in February of 2026, and it had to do with text messages, the subject of a reply to a motion in limine. So here we are. A look at the docket today reveals that nothing has been released to the public. From those 89 still pending documents ordered to be unsealed December 18th, 2025. And moreover, this 4th court order seeking the parties' position regarding sealed documents that would finally get matters into 2024 still is not on the docket. So this activity of unsealing documents that Judge Hippler announced last year would happen after denying the media's request to unseal the case in July has come to a standstill. For all intents and purposes, there has been no explanation as to what is going on with the unsealing of the case. We're going to continue to monitor the docket to provide you with updates as they arise. Until next time, this is Kathy. Thank you for joining us here today.